I still feel I have to learn so many things more. So one cannot say that I have learned everything, I know everything. If you become an advocate, what type of behavior you have towards your client, towards your opponent, towards the court, towards the society in general. It's not only limited to that you wear a uniform and go to the court and contest your case, I'll do your matter and come back. There are so many ifs and buts attached to it. First of all, you have to have a good knowledge of law when you become an advocate. You have to have command over language. You have to choose the words what you want to speak. You have to be prepared very well with the brief. Brief means facts of the case. Unless and until you are prepared with the case, you cannot present your case before the court. Firstly, you have to satisfy yourself about the facts of your case of your client. Then only you can satisfy the court. You may be preparing your brief very well throughout the day, night, days together, weeks together. You are preparing your case, and you feel you are there cannot be. You cannot assume that you will have a lawyer, because ban is the only guarding thing which nobody can bear, excepting an advocate, registered advocate. In High Court, you have to wear the gown. Of course, nowadays, like it's very hot and all, so they exempt it for 2 months. Even court is exempted in subordinate courts because of scorching heat and all. But in High Court, otherwise, you cannot appear without a gown, without a band, without a coat. You have to wear the uniform, the band, coat, and then the gown. You can address the court only then. So now Advocates Act further describes that wearing band and gown in public place is prohibited, because it is needed only for an advocate in the court premises, courtrooms. But exception is there. If there is a public function in some hall like Constitution Club or something where the advocates and judges are coming and all, it's the official function, you have to be in uniform where you can wear the bands and the gowns. That's the difference. Now coming to what are your duties towards the client, number one. When any client comes to you with a file and facts and documents, the first thing is very comfortably talk to your client. Why? Because already he is in problem. He has come to you for redressal of his problems. Now the discussion starts and the client starts with the problem. For example, suppose it's a matrimonial case. The wife comes to you and tells about the problem she is facing in the matrimonial house, from the husband, from the in-laws, from sister-in-law, or whatever, whosoever is in the family. Maybe out of the discussion she will repeat few things, because she is in problem, distress and disturbed mentally. Don't snap her. That don't repeat it. You have said it once, twice. Why third time? No. Listen the client comfortably and start making the brief of the facts on a sheet of paper. Note down the facts, the problems, and then you tell her to come after 2-3 days so that you can go and leave the documents with you. So that you can go through the documents, you can go through the facts, match the facts with the documents. Suppose she says, I have written 3 letters to the police station or something. Match it with the documents she has handed over to you, whether in fact there are such letters and complaints or not. Arrange the documents date-wise, and after 3-4 days when the lady comes to you, tell her what relief she wants from this, through you from the court. If she wants a divorce, tell her that yes, I will be filing a case for divorce for you. It will take on such and such date, and my license is suspended for some time till the time I rejoin. If you don't want to rejoin, it's fine. After 2 years, you find this job is not good. I don't want to continue with the job. I want to practice again. So you come back, make an application to the bar council that I have left the job with the technical date and my license is likely to revoke. again, and you can practice. There is a case where a person was handicapped. His name I know it from there. Govinda Kumar. This is Pathankot case. Just to make you understand what happens. He was handicapped. In the court premises only, he got a premises for documentation and photocopy center. He was running that. Under the handicap quota also from PNP department, you must be knowing earlier we had PCOs, public call officers, where from people used to take call, and SPD officers now the mobile is very old case. So he from PNP department he had taken a PCO also in his name. At the same time in a private coal company he was a general manager also. He was a registered advocate also. So there was a complaint against him that he is practicing also, running his documentation and photocopying center as well, PCO, STD also, he is in full-time job also. Now, the complaint was made in the bar council. It was marked to the state bar council, and ultimately he was suspended from practicing for his life with fine. That time 500 rupees or something like that. The matter went up to Supreme Court, and the Supreme Court said that fine has to be imposed, and for life we are prohibiting him from practicing, so let it be reduced to 6 years. So it was reduced for 6 years. So you cannot have a full-time job or business like that when you are practicing advocate. You have to have full-time devotion to the professional work. Now what are the misconducts? There are minor misconducts, there are major misconducts. What are the misconducts like? Very serious misconducts are also there, for which we have contempt of court proceedings also. But normally the things don't go to that extent. But misconduct complaints are, thousands of complaints are pending in Bar Council of India and Bar Council of Delhi by the clients against the advocates for misconducts. Few examples I give. You must have heard in newspapers and channels that while these flyovers are being made, where this railway, this metro work is going on, nearby areas are taken by the government for laying down the metro projects and other things. So adequate compensation is given to the persons concerned whose land is being taken by the government. So in one of the cases, in many cases, what happened, the compensation was given to the person concerned whose land was acquired by the government for these purposes. Whenever you work for any client, there is a wakalatnama, which is to be signed by the advocate as well as the client, and which is filed in the court to show that you are, and prove that you are the counsel and you are the advocate for such and such client. There are many, many terms and conditions in that wakalatnama, more than 20, which normally the client never reads. The client just signs or puts the thumb impression on the wakalatnama, and you are the advocate for the client. In that wakalatnama it is also mentioned. This is also one of the, if I don't know criminal law, I apply for bail, the person will be jailed. It will not be a bail, it will be a